somebody better hide the ketchup, Mar-a-Lago, because Donald Trump is about to be furious. A federal judge has now ruled that special counsel Jack Smith will be allowed to file hundreds of pages of new legal arguments and evidence gathered in the 2020 election subversion and January 6th Capitol attack criminal case against the former president. Filing is expected to be the largest chunk of the case against Trump the public will be able to see prior to the 2024 presidential election. And remember, the actual trial is going to take place after the election. So the trial, of course, is where you're going to see the most evidence get played out. Unfortunately, Donald Trump has been very successful in pushing back that trial date until after the election, which, if he wins, he's going to use his power to reorganize the DOJ to make that case disappear. So this is one of the cases that would go away if Trump is able to win the election. So now, the filing could include what prosecutors know of the former president's interactions with then Vice President Mike Pence and other important moments in late 2020 and early 2021 involved with, of course, his attempt to steal the election. So now the decision was made by Judge Tanya Chutkan and allows the Justice Department to put into the court record parts of the investigation against Trump that are not yet publicly known. So guess what? We're going to find some new stuff. As if the stuff that's already known isn't bad enough for him. No, it's actually going to get worse. The brief due on Thursday is expected to exceed 200 pages, including exhibits, and is meant to convince courts that Trump should be prosecuted for alleged obstruction and conspiracy criminal activity. Chutkan, in her 6-page opinion, said she would allow such an outsized briefing because the Supreme Court, in its recent decision to give Trump's actions while president immunity from prosecution, has directed her as the trial judge to look closely at the facts in the case to decide if some of the allegations could move forward to trial. So, yeah, she's looking at the facts, and it's like, oh, yeah, there's a lot of stuff here. There's a lot of stuff. 200 pages. So here we go. Not good for Trump. So now, even though the trial will not happen before the election, thanks to the appeals and as well as the Supreme Court, it's still very possible we're going to see a lot of evidence. Now, it's not guaranteed. This will be filed under seal. However, Chutkan does have the ability to release a version of it to the public as part of her court file. The DOJ is also planning to provide a redacted version that could be quickly released by the judge, likely before the presidential election. So if you're looking for an October surprise, this would be it. This would be the October surprise from Jack Smith, who ain't done yet. Okay. Now, Smith's office, for example, told Chutkan recently that it wanted to make a detailed accounting of the facts of the case to the court with substantial evidence attached. Substantial evidence. Which is not good for Trump, whose team, of course, has wanted to push this off until after the election so he can make it go away. Now, Smith is dead set on not allowing that to happen, which is good. That's a good thing. Chutkan also wrote, in expectation, the Trump team will argue against this decision. Quote, making public evidence in legal disputes over immunity in the case wouldn't affect witnesses' potential testimony or the jury pool. Because, again, they're going to try to make that argument. She also said that the other arguments the Trump team has been trying to make about a Justice Department policy not to influence a campaign politics in the 2 months before the election day isn't actually part of her job. Quote, the court need not address the substance of those claims. Defendant does not explain how those putative violations cause him legal prejudice in this case, nor how the court is bound by or has jurisdiction to enforce Department of Justice policy. So, and remember, the reason that this is so close to the election, by the way, is not because the DOJ decided to just randomly bring it right before an election. No, it was brought a long time ago, but there were delays after delays over and over by Donald Trump's team, making sure that it gets delayed until after the election. look, the trial should have been done by now. But Trump said, no, let's delay this as long as possible so I can either get rid of it if I win, which is disastrous, or have it close to the election and claim that this is just election interference. He's one to talk. I mean, it's kind of like Comey bringing up Clinton's emails. That's the inspiration for this argument that Trump is making. But it is two different things. You had one that was very political, okay, Comey bringing up Clinton's emails. The other, Donald Trump's attempts to literally overturn an election. A conspiracy. So, I mean, big difference on that. And so Chutkan is allowing this to go forward, and we're going to see some new evidence. Should be very interesting. Thank you for watching. If you enjoyed this video, please like, share, subscribe, hit the bell icon in order to get notified whenever a new video is released. And if you want to support independent, progressive media through this difficult time where it seems like everybody is shutting down, you can become a member on our YouTube page, you can become a subscriber on Facebook, or you can go to my Patreon. It's patreon.com/Jeff Waldorf. Thank you.